Welcome to the Wednesday colloquium of the Minerva Center for the Rule of Law under Extreme Condition. It's a pleasure to host today Dr. Antal Berkes. He's currently a lecturer at Brunel University for Public International Law. And his interests are international human rights law, international humanitarian law, and the refugee law. And this is connected to the talk that he's going to give us on opposition group and compliance with international law. Antal has been a postdoctoral research fellow in 2019 at the University of Pretoria, where he worked on his forthcoming book at Cambridge University Press, International Human Rights Law in Areas Beyond State Territorial Control. And if I understand, your presentation is connected to the theme of the book. Antal, the floor is yours. We will, of course, take comments and questions following your presentation. Welcome.
Yeah. Thank you so much, Eli, and thank you so much also for giving me the floor on behalf in the framework of the Minerva Center, especially as very much the project on the tribunals of armed group on opposition groups were enabled through a generous financial fund of the Minerva Center. And here I will share my screen just to show you some examples which I have found through this project. Yeah, so thank you so much for giving me the floor, and welcome to all of you. The topic is the compliance by the tribunals of armed opposition groups with international law. As we know, compliance with international law undoubtedly depends mainly on non-legal factors such as legal culture, public opinion, ethics, or religion or reciprocity, and very much the topic itself has been elaborated on by political scientists, international relations scholars, and also, last but not least, by legal scholars, especially as to the consequences of the legal consequences of compliance. The compliance question applies a fortiori to armed opposition groups, whose legal subjectivity is often not recognized by states and is only subject to certain special branches of international law, such as IHL, international humanitarian law, or international criminal law. The case law predominantly illustrates that armed opposition groups more often violate than respect international law. Very few examples show that there might be compliance with certain rules of international law by armed opposition groups. This negative picture follows in part from the special rules of IHL and international criminal law, in part from their control mechanisms that tend to scrutinize the violations rather than the positive examples of compliance. Armed opposition groups often lack institutional, human, or financial resources to really effectively comply with international law. Few armed opposition groups have, however, been stabilized and created sophisticated state-like structures, including courts or tribunals. This is what Marco Sassoli called sliding scales that is needed to provide for increasing obligations the degree of the organization, or in a similar sense, the present UN Special Rapporteur on extrajudicial executions also recognize that the obligations of non-state armed opposition groups depend on the nature of their control and also their degree of organization and their capacity to comply with international law. In the existence of available and effective courts is also a requirement for the right to effective remedy and the fair trial rights under international human rights law as far as they bind armed opposition groups. More generally, fair and efficient institutions of justice, like courts, constitute one of the basic fundamentals of the rule of law. The rulings of armed opposition groups, if they are available, could be an instructive source to illustrate the quality of the law that armed opposition groups in practice apply. While compliance of those groups with international law has been assessed through international control mechanisms under the special regimes, IHL, international criminal law, scholarship has almost fully ignored the internal law of armed opposition groups, mainly for epistemological reasons. We do not know them. The armed opposition groups rarely publish them, and to fill this gap, this empirical research tries to analyze the decisions of tribunals by armed opposition groups. They show that the more an armed group evolves to a state-like structures, the more it is capable to comply with international law. However, another criteria for compliance is obviously the willingness of the group. And I will show in this short presentation that the degree of willingness to increase the legitimacy of the group in the eyes of domestic and international community is very much the major factor to increase the compliance with international law. The sources that I would like to exploit are again primary sources from certain tribunals of armed opposition groups, especially those who have been stabilized, often called as de facto regimes. The database where I have already published some of them is already available, the armed justice by armed opposition groups, but that it will be still developed further. In my presentation, I will proceed as follows. First, I will explain some already existing compliance theories that scholarship proposed to analyze or to explain the compliance by armed opposition groups with international law. They are limited to the special fields of IHL and international criminal law, where armed groups enjoy a partial legal personality, but cannot sufficiently explain why those armed groups comply with other sources of international law, and especially why they choose to follow other new sources of international law. And those new ideas were exploited in judgments of armed opposition groups. I call them alternative compliance theories, and those decisions demonstrate that various ways of interaction of those groups with the international community is a feasible way how an armed opposition group increases its compliance with international law. First of all, what are the traditional compliance theories? First, they provided some explanations on compliance with international humanitarian law by armed groups. A first such theory include basically international individual criminal liability based on the repressive force of international law. However, the weakness of this theory is that international criminal law only sanctions the authors of the most serious crimes of breaches of IHL, but does neither seem to prevent international law violations below that threshold, nor instigates the respect of other norms of international law. A particular example for individual criminal liability that many of you have already studied in details is the war crime of sentencing or execution without due process, which is criminalized under Article 8, Paragraph 2, Subparagraph C4 of the Rome Statute. It uses the requirement for a regularly constituted court, and it is in the elements of crimes a non-binding commentary for the Rome Statute which defines regularly constituted court, a court that fulfills the essential guarantees of independence and impartiality, and moreover affords all the judicial guarantees of independence and impartiality. It is an explanation that is much more favorable to use courts by armed opposition groups, but it hardly eliminates the operation of armed opposition groups because the crime is restricted to criminal trials against persons taking no active part in hostilities, basically members of the armed forces who have laid down their arms and placed hors de combat, but leaves unrestricted trials by armed opposition groups in civil or administrative matters. Therefore, it hardly increases the overall international law compliance of de facto courts outside ILJ that basically the Rome Statute does not intend to govern. More generally, humanitarian experience shows that an approach based on only punishment and sanction is not always effective in enhancing compliance with international norms, and therefore authors have searched other solutions. The second possible understanding or explanation for the compliance with international law by armed groups is non-recognition. Some authors invoke non-recognition as an automatic consequence of the maintenance of a situation resulting from the most serious breaches of international law, so the famous peremptory or jus cogens norms. This legal basis only approaches armed opposition groups from the viewpoint of sanctions, that does not explain why armed opposition group would be interested in respecting international law rules other than peremptory norms. In fact, non-recognition by states does not assess international law compliance above the threshold of serious breaches and of peremptory norms, and often entails the hostility of armed groups towards international law. A third quite innovative mechanism and the dominant mechanism or explanation to explain the compliance by armed groups is based on mechanisms that instigate ownership by the armed opposition group over rules of international humanitarian law. It is about informal dialogues, monitoring, self-engagement, or more generally the convincing of the armed group to comply with international law for various benefits. Some works on compliance use theoretical arguments, while other empirical arguments. Here to explain this, the effect of this informal dialogue. Here I refer to the 2015 book To Hear and Show, Compliant Rebels Groups and International Law in World Politics, who also engages in the combined understanding of engagement through theoretical arguments and also empirical analysis. He uses, for instance, commitments or declarations where the armed groups express their willingness to comply with international law. He also recognized, and then various authors critically recognized, that those commitments might be far away from the reality and could overshadow their practice, which is very much in violation of international law. Another empirical data that he is using is humanitarian practices of armed opposition groups, such as granting access to the ICRC by the group to rebel detention facilities. Again, the problem is that this might neither reflect the overall compliance record nor the reasons of compliance of the armed opposition groups. Especially, there might be various factors to grant access to the ICRC to detention facilities. While this explanation based on engagement and over ownership innovatively illustrates tendencies of armed groups, there might be a gap again between the outside communication of the armed group and its effective conduct. Furthermore, previous scholarly works are still limited to the sphere of international humanitarian law and hardly applied to other branches of international law. Here I note that the internal practice of armed groups, however, is clearer evidence on the law as applied by the given entity, especially if judicial bodies exist in the given armed group. I will explain that tribunals of certain stabilized armed opposition groups, especially of the de facto regimes, show a certain tendency of interaction with the international community. I certainly do not claim that they respect international law as an overall tendency, but it is a feasible, at least some judgments show a certain willingness to invoke and apply international law in practice. It is feasible, so this is a feasible source to increase their legitimacy on the one hand, and also their compliance with international law on the other hand. So what are those alternative compliance theories? The sources of armed opposition group tribunals show at least two tendencies. The first is, which were a little bit ignored by scholarship. The first is that the courts of the so-called de facto regimes do apply a wide range of sources of international law through an inheritance from the legal regime of their territorial state. In other words, their compliance can be explained by the inheritance of international law friendliness from the legal system of the state, which they intend to fight and separate from. And the other alternative explanation is the various interactions of those tribunals and the armed opposition groups with international law sources. Especially, I will refer to confidence building measures, trade, status negotiation, the training of judges by international courts, or the simple direct interaction of state courts with courts of armed opposition groups. Let's start with the first alternative explanation: inheritance of international law friendliness. Here, as a matter of fact, while most armed opposition groups ignore international law instruments, especially because of their lacking human resources and appropriate training, some de facto courts continuously operated as part of the justice system of the territorial state, and once the civil war started, as part of the newly created armed opposition groups. Here again, I refer to Common Article 3 of the Geneva Conventions, which provides the passing of sentences and carrying out of executions without previous judgment pronounced by a regularly constituted court, affording all the judicial guarantees, which are recognized as indispensable civilized sources. This Common Article 3 prohibits the executions by those armed opposition group tribunals which are not regularly constituted and do not afford judicial guarantees. Here again, two rivalizing, conflicting interpretations have been provided by scholarship. The first is the restrictive reading, which interprets the criterion of regularly constituted court as a court which is created under the territorial state's domestic law. So it would automatically exclude the courts created under the internal law of the given armed opposition group. A broader view, rather dominant view today, is that adopted by the new commentary of Common Article 3 of 2016, which accepts the regularly constituted as based on the internal law of the armed opposition groups that can therefore conduct trials in conformity with the requirements of judicial guarantees under Article 3. So the debate of the meaning of regularly constituted is certainly of importance and critical, but here I just note that under both interpretations, the courts which were inherited from the territorial state and that continue to operate continuously within the armed opposition group certainly satisfy this regularly constituted court criterion of Common Article 3. They have often been ready to apply international law sources, and here, if you allow me, I will just refer to various examples. Examples include the FARC in Colombia, the Liberation Tigers of Tamil Elam in Sri Lanka, or various Caucasus courts that I will show you some decisions, or the Turkish Republic of Northern Cyprus, which has continuously applied international human rights standards from the territorial state. One particular example is the Supreme Court of this Northern Turkish Supreme Court. And here again, my conclusion will be that those decisions and examples show some readiness to apply international law sources binding the territorial state. One particular example is a scholar example from 2003 from the Supreme Court of the TRNC, where the court recognized that the European Convention on Human Rights is part of the domestic law and is at the same level as its own ordinary law. If a domestic law is in contradiction with the clear provisions of the convention, it is up to the domestic court to apply the convention. And again, as a reasoning, the Supreme Court refers to the former constitutional structure of the Turkish Federated State of Cyprus, which attributes particular legal status to international conventions, especially the European Convention on Human Rights. Another example comes from the Donetsk People's Republic that has largely continued to apply the Ukrainian laws in force for very practical reasons to ensure continuity, including international human rights conventions, such as the European Convention on Human Rights, the ICCPR, or the Convention on the Rights of the Child. Here, an example from 2016 is the Donetsk court's ruling, where the court rejects the cassation complaint in matter of a claim for the father's deprivation of parental rights. And the court invokes the parent's primary responsibility for the raising and development of the child on the one hand, and also the famous best interest of the child based on the New York Convention on the Rights of the Child and the Ukrainian family law on the other hand. So again, continuity is the main reason to apply international law in this case. Another example is the continuous application of the Ukrainian Civil Code and the International Covenant on Civil and Political Rights in a dispute of divorce, where the court from Donetsk, from Makeyevka, voluntarily referred to the ICCPR as a reasoning to back up the Ukrainian Civil Code solution on basically the tribunal's decision to pronounce on the divorce. So this has been largely the case law of de facto regimes of the post-Soviet space, where the armed opposition group inherited the old Soviet regimes, and especially in the 1990s, even democratized to certain measure those international law sources and those post-Soviet laws. Consequently, the de facto judges are familiar with major international law instruments originating from their pre-independence, pre-war, civil war phase, and their constitutional instruments have often incorporated that tradition. In Northern Cyprus, the de facto courts apply the Anglo-Saxon legal tradition, so basically the common law, openness to international law, and also I just recognize as a limit of all this case law is that inheritance of legal traditions is in itself not a guarantee to respect international law. While the courts of Donetsk People's Republic tend to apply international law instruments in civil and administrative matters, UN reports largely show that there are still serious breaches of international human rights and humanitarian law in criminal matters. And especially those criminal courts are not likely to satisfy the basic conditions of impartiality and independence. Likewise, however, the inheritance of the law of the territorial state and legal traditions, while do not explain in themselves, while certain armed groups adhere to new rules of international law. For instance, in South Ossetia, where the legislation has integrated the Russian law to South Ossetian realities, the judges rarely apply international law, and I still do not have any judgment where international law rather than Russian domestic law is directly involved by. So beyond inheritance, so the continuous application of the territorial states law. There are other solutions to explain why certain courts of armed opposition groups apply international law, and those are the interactions with the various interactions with the international community. So I could refer to various types of interaction with states or international organization where armed opposition groups had some certain contacts with international law. Examples include informal interactions with another state's judicial system, the informal dissemination, especially the training of local judges, practice widely used by the Council of Europe bodies and also some UN senior experts, but also various NGOs. The informal dissemination, beyond the informal dissemination, one can mention engagement or dialogue with local judges in status neutral setting, especially the status neutral mechanism of international organizations, or non-binding monitoring by international organizations. Here, I can refer especially to training as a social legal mechanism to try to increase the awareness and compliance of local judges with international law. For instance, the de facto authorities in Nagorno-Karabakh have adopted Armenian laws almost verbatim, while the local judges are in constant training and interaction with their Armenian counterparts. Most judges from Nagorno-Karabakh were trained in Yerevan and demonstrate some familiarity with Council of Europe standards. Armenia has given more formalized assistance and training on a ministry-to-ministry basis, but also direct prosecutorial and judicial assistance in major cases. So the local judges are keen to apply international treaties binding also Armenia, even if they are not formally bound by them. One example is a case from the first instance court of Stepanakert from 2016, where the ILO termination of employment convention was applied by the local judge, which otherwise does not apply in labor disputes directly in Nagorno-Karabakh, but indirectly as a source of inspiration inspired by the Armenian legal system. Likewise, judges from South Ossetia occasionally travel to South Ossetia and try to provide training for the de facto judges of South Ossetia, but there are certainly less exchanges with the Western tradition of international law compliance. Various international organizations provide training to de facto judges. I refer again to one particular example where it is, I do not have the text of the decision, but Transnistrian courts incorporated the UN Convention on the Rights of Persons with Disabilities as an answer to the encouraging and multi-cycle visit of Thomas Hammarberg, who largely disseminated the importance of international law on the rights of persons with disabilities. Another example that I would like to show is another Nagorno-Karabakh case where local judges have acquired familiarity with the European Court of Human Rights case law, and the local judge in a criminal case of 2018 interpreted the criteria of detention under the principle of reasonable suspicion, so in accordance with the case law of the European Convention on Human Rights. Another noteworthy example where the local judge even combined various sources of international law relates to the contact rights of the father. Here, the judge referred to the Convention on the Rights of the Child and the most recent European Court of Human Rights case law from 2010 and 2011. Finally, perhaps the most compelling argument about the persuasive force of international law in cases are cases where the de facto judges were able to rule in favor of the individual, but against the bodies of the armed opposition group itself. This occurred, for instance, in a civil court enforcement judgment in Donetsk, where the local court rejected the request of the state enforcement service, the armed opposition group enforcement service, to restrict the debtor's right to leave the territory of the Donetsk People's Republic. It means that based on international law sources, the judge was able to recognize the freedom of movement of the individual and rule against the armed opposition group's official bodies. So it enshrined basically the requirements of the European Convention on Human Rights and the International Covenant on Civil and Political Rights. Another compelling argument where the interactions of the armed opposition group with foreign sources, especially international law sources, are visible is the trade. So trade is obviously a pragmatic, compelling reason to use outside sources. Trade with any company outside the territory controlled by the armed group entails the application of the rules other than the domestic law of the armed opposition group. This might naturally entail the appreciation of foreign and international law as a guidance. One example is the Interpipe Ukraine case. In Nagorno, it's again a case from the local court of Nagorno-Karabakh, where a local company asked for the recognition of an arbitrage award made by the Trade and Industry Chamber of Ukraine. While doing so, the court satisfied this claim and took into account the principles established in the 1958 New York Convention on the recognition and enforcement of foreign arbitral awards that otherwise did not apply to Nagorno-Karabakh. So what is interesting here is that the local judge clearly refuses to apply directly this 1958 New York Convention. However, it goes further and it applies the universally recognized principles of international law as enshrined in this convention. Especially among those principles, the court highlighted the principle of reciprocity and the principle of good faith, the bona fide, to recognize foreign arbitral awards. Finally, the judge stressed that the latter is an expression of the civilized attitudes towards foreign law. This is quite clear in this to see that there is some compliance with international law by armed opposition groups. And here I just note also that in status negotiations and peace processes, there might be other instigations from the state, the territorial states part, where the territorial states gradually integrates the law of the given armed opposition group in the state government with the corresponding gradual harmonization of the law of the harmonization group. Positive examples include the FARC negotiations from 2014-15 and the Transnistrian de facto administration, which also engaged in a long-term negotiation process that led to different results. I just note that here one of the agendas of the Transnistrian status negotiations is the mutual recognition of civil law judgments, especially as to ownership and property rights. However, it is not certainly not a concluded and terminated agenda of the negotiations, but the aim or one of the possible outcomes is the mutual recognition. However, as the analysis of state practice illustrates, both processes had positive impact on the compliance of de facto courts, and especially in ordinary civil law and in international human rights law. So these are some examples for the legitimacy raising interactions with the international community by armed groups, and also it also shows that those judgments do play a certain role in making or decreasing compliance by armed opposition groups. As previous scholarly analysis recognized, armed opposition groups who rely on foreign sponsors with human rights organizations or international NGOs like the Geneva Call are more likely to comply with international law. And here, instead of true conclusions, I would rather invite you to continue these discussions. First of all, ultimately, all these alternative compliance theories confirm that the respect of international law is a sign of evolved statehood. The state practice shows that judicial decisions of armed opposition groups might matter. This is the case when the armed opposition group engages in an integration process and also in the application of international law. The practice of status negotiations and peace processes provide sufficient state practice to claim that such integration processes promote the compliance of the armed opposition group with international law. But all this argument is admittedly circular. Integration processes go hand in hand with the increased recognition of the non-state entities' capacity and willingness to comply with international law, but the compliance with international law is also promoted by those interactions with international law. So, and especially with the courts, with the de facto courts interaction with international law. And here I will conclude with rather a series of questions that I still could not answer, and which I just invite you to reflect upon. The first is really the elephant in the room, which is the interest of states. Are the states really interested to promote the legitimacy and international law compliance by armed opposition groups? State practice rarely contributes to the operation of unrecognized courts of armed opposition groups, not to speak about the recognition and the validity of the decisions of those courts. Quite important IHL example is the commentary to Common Article 3, which affirms that nothing in the provision implies that the state must recognize or give legal effect to the results of trials by non-state armed opposition groups. This is consistent with the final paragraph of Common Article 3 with respect to the legal status of such parties. And also one could ask, what would be the purpose of imposing independence and impartiality fair trial guarantees on those armed opposition group trials as a minimum standards if they could be left without any legal effect, and especially not respected by states at all. And here further examples could be raised to question the future conduct of states with regard to tribunals of armed opposition groups. For instance, supposing that the armed opposition group respects the minimum judicial guarantees, what are the lawful compliance enhancing measures that the international community is willing and can take to promote those trials? For instance, is it lawful to cooperate by state tribunals with armed opposition group tribunals? Here, certain examples show the ambivalence of this interaction. The transfer of evidence or files from state courts to armed opposition group courts is very problematic. For instance, in the Güzeli-Yurtlu case from last year, the European Court of Human Rights held that this might be a sovereign limit of the cooperation with those non-state armed groups, and the state under the European Convention on Human Rights is not obliged under the right to life to transfer evidence to those armed opposition groups as far as the transfer would complicate or even renounce the sovereignty of the given state. Or more complicated, the transfer of criminals from armed opposition groups to state prosecution. This is an extremely politicized scenario, and the recent example is the endless requests transfers sent by the Kurdish self-governing administration to the states of nationality of foreign terrorist fighters. Or what are the lawful limits of recognition of decisions of armed opposition groups by states? Again, as a pragmatic observation, it is less problematic with regard to acts concerning personal status, birth registration, marriage, divorce, or death certificates issued by the armed opposition groups tribunals. This also follows from the famous Namibia exception from the Namibia advisory opinion of the International Court of Justice, but also some precedents of partial recognition or accreditation shows that broader questions of civil law judgments from armed opposition groups might have some legal effect in states. More problematic is the ordinary crimes judged by armed opposition groups, and the most problematic certainly with regard to political crimes or international humanitarian law decided by armed opposition groups. Here I refer to a pending case before the European Court of Human Rights, the Asgarov-Veselova versus Armenia case, where the question is the legal effect of a conviction by Nagorno-Karabakh for crimes of espionage, arms possession, or kidnapping and murder. But also more complicated is, again, the status of status-neutral mechanisms that international organizations do afford and provide to build capacity of armed opposition groups, whereas it might go against the will of states. And here, I conclude by thanking you so much for your patience, and I am looking forward to your questions and comments. Thank you.
Thank you very much, Antal. It was very, very interesting, and we have already on our list Robert, Amnon, and Shelley, but I want to ask a clarification question before. When you talk about the concept of armed opposition group, I gather from the subject that you talk only about armed opposition groups that actually control parts of territories, not all armed international armed opposition groups. And I just want to ask you how many cases now are actually such that there are territories that are controlled by non-state organizations?
Yeah, thank you so much for the question. I should have clarified it at the very beginning. So yes, you are absolutely right. One particular and pragmatic limitation from the practice is that only armed opposition groups with a stable territorial control, arguably those who can satisfy the additional Protocol 2 criteria, can also establish stable courts and the justice system. Another limitation of all this practice and the examples that I raised is that only with a certain stability can we speak about operative justice system. So I voluntarily and also as a lacking practice, I had to exclude those armed opposition groups that were alive and operative for certain months only, whereas most of the examples I found are the stable de facto regimes which operate and are functional for many years or even decades. Most of the examples I have found and provided are from the Caucasus, so the 5 or 6 de facto regimes that still exist from the 1990s, so basically Transnistria, Nagorno-Karabakh, the Northern Cyprus, also the 2 de facto regimes in Ukraine, Lugansk and the Donetsk People's Republic, and those 2 from Georgia, Abkhazia, and South Ossetia. Other examples could be the Gaza authorities, where I still do not have any written examples, written and published judgments, but certainly the scope of this research could be extended to other de facto authorities. We will see how the practice evolves in other continents.
Thank you very much. I have more questions, but it will wait. Robert, the floor is yours.
So just before, first of all, thank you for the honor to be responded for such an interesting presentation. But before I even begin, the Israeli legalist here would very much be familiar with some of the argumentations and maybe legislation, if you could call it, that you've presented as to continuity, for example. It's almost word by word the Israeli act on taking and continuing legislation from mandate law into Israeli law. So there's a very familiar point in that, and we have some experience, for example, with dealing with not exactly the same case with some Palestinian courts who took the liberty to prosecute for security offenses, which they shouldn't have, terrorists, and then we had the question of double jeopardy here. So things that kind of similar in that sense. So back to my response here. First of all, thank you very much, Dr. Berkes, for a very insightful presentation. I think the AOG's compliance with international law deserves indeed much closer examination and better understanding. Most of all, it is not merely compliance as such that we seek to achieve, but a better protection and appreciation of human rights, as the very existence of AOGs is inherently entangled with a situation that threatens human rights and human lives. So if we can find the key to achieve this better protection that we seek, this will solve a riddle that we have to have better compliance with international law, and that will be a major breakthrough. So I think it's important, also important the discussion that we're having, because we're living in a time that we increase the impact of non-state players on international law, its relevance, its implementation, its development. Non-state actors are gradually making their way to the center of stage, where states were and maybe still are have their supremacy. States have even become equally dependent of non-state actors. Okay, a good example would be the ICC. Is a tribunal is a non-state actor which plays a growing role not only on the issues of ICL but in IHL as a whole. For example, when it deals with the question, what is an attack under the Rome Statute, this of course affects the entire understanding of international humanitarian law. If you take it to the extreme, you have the decision that the ICC we're waiting for it to rule on this question of statehood of Palestine. So we actually have a non-state actor which will determine statehood. This will have even greater effects of, far beyond the Rome Statute. So the first point I want to make would be that the court, we should look at the AOG's court's compliance with international law in a broader context of development of international law as a whole, and particularly the international humanitarian law, the laws of war. This may be the future of international law, not just a state-made law and a state-implemented law, but something much more complex. What I'm saying is that implementing international law and norms may not just be a step towards statehood by non-state actors, but also a step from statehood-based international law towards something else, which is towards AOGs and non-state actors too. So this will bring me to the second point, and Dr. Berkes also mentioned it. And generally speaking, most AOGs do not respect international law. And most importantly, as we speak of armed groups, it would be international humanitarian law. And it will brings me to ask some critical questions as to the meaning of AOG's court reference to international law, and maybe put some issues in perspective. The first question is, can we deduct from the fact that an AOG court cites international sources compliance with international law in general? And contrary, would we say that non-reference to international instruments proves otherwise? For example, just a year ago, I attended the Minerva Center conference in Jerusalem, where my friend and colleague Liron Liebman presented a research conducted in Israeli military courts, according to which military courts dealing with IHL violations generally do not refer to IHL instruments. They rather speak of morality and values, cite international instruments, but they rarely cite international instruments. That will not necessarily say that this reflects non-compliance. So the question of compliance must be answered looking at the whole picture. If you wish, the practice of the AOG, the mere citing of international sources, mostly not in a constitutive way, but reference by the court, is not the only tool that we would assess compliance. Second, and I think the real test in compliance is not when it is comfortable for the AOG to refer to international law, it is where it is not. When compliance is inconvenient, when it comes with a price. So what we would be looking at mostly to better assess compliance, it's the places that the court really has to make a way and pay a price by this compliance. So it will be, again, mostly in international humanitarian law. I have a lot to say about it. The international law, the issue of compliance to international humanitarian law is not something which is troubling as to AOGs. It is also a question the doctrines are not given enough answer, even as to states' compliance to international humanitarian law. In many ways, we still remember Hersh Lotopas saying that if international law in some ways is the vanishing point of law, then the laws of war are perhaps even more conspicuously the vanishing point of international law. So if you take it and refer and the doctrines that as to states' compliance with international humanitarian law to AOGs, you'll find some similarities and some things that are not always the same. But I would just finish with one issue and one maybe one contribution I may have as to alternative doctrines that Antal you presented. Just as to IHL, a few years ago, Professor Ben-Venisti and Professor Amchai Cohen suggested a new theory as to why states comply with international humanitarian law, and this will maybe something that be relevant also here. Their article, War is Governance, explaining the logic of law and laws of war from a principal agent perspective, they argue for a reasoning which is basically for domestic needs of governments. So they argue that commanded militaries and their civilian leadership need IHL indeed, but a kind of IHL which is specifically tailored to control the agents because of the collectively face a daunting challenge of controlling their respective troops. Okay, so the idea is that compliance serves a domestic tool to control the governments. I saw it, for example, in one of the cases that you have in your on your website, in the Moldovan case, when you have the president appeal to the court rejected, referring to international law on that in that case. And in that case, in what I'm saying, it's not only legitimacy that matters here. It serves as another function, an internal function in this states. So in this AOGs, not states. So that would be my last point. And thank you so much for such an interesting presentation.
Antal, the floor is yours.
Thank you so much for all your thought-provoking reflections and questions, Robert. I can fully subscribe to your remarks, especially as to your criticism about and also the analogy with compliance questions with state, with the compliance of states with international law. And I will just try to further elaborate that on the pathway you just suggested. So the first question is, can we really deduct from references to international law by armed opposition groups, tribunals, the fact that they really truly comply with international law, or reversely, if they do not refer expressly to international law, does it mean they do not respect international law? And again, I do not have another answer than to refer to the fact that you mentioned also that the same problem arises with state courts, especially when they refer as rhetorics to international law, while the practice shows or completely otherwise, or where the reasoning, the discursive technique of invoking international law is used to refer to defer from the solution international law is governing. So this is very much a broader question, and I truly I can only subscribe to a better study of the combined analysis of the decisions and the practice. Here, perhaps another way to refer to pragmatic examples is exactly the way that you proposed in your second question, is the cost-effective, cost-benefit analysis. Does the court of an armed opposition group have to pay a price for compliance or for non-compliance, and is there a direct benefit? Again, very difficult to find, especially if I compare the practice of those courts with monitoring mechanisms of international organizations, especially international human rights organizations, then very often I see this contradiction, that whereas the courts in civil or children matters, child protection matters refer to international law, the monitoring bodies still find the deficiencies of the practice of the given de facto regime. One positive example that comes to my mind is the famous TRNC, so the Turkish Republic of Northern Cyprus, decades-long dispute about the property claims of old Cypriot owners in the territory of Northern Cyprus, where it was finally with the aim and active intervention of international organization that an arguably independent and impartial judicial or quasi-judicial mechanism was set up in the territory of Northern Cyprus. It certainly showed that the discursive technique of the decisions of this internationalized but de facto and court and the practice of the given armed opposition groups are on the same side, and which was also positively evaluated in some later decisions of the European Court of Human Rights. So here I see a clear example of match between the practice and the decisions of this de facto organ. Your other question, and I would not like to be too long, is compliance a means to control the government? I see this again in analogy with states, as you saw it. I just refer to this wonderful book of here under you about compliant rebels groups and international law in world politics, where he uses this notion of legitimacy for both internal and external legitimacy, in the sense internal in the sense that it is a means for the electors, basically, of basically the population governed by the armed opposition group, to gain their sympathy and gain their support, and also to gain their confidence in controlling the armed opposition group. Very much in accordance with what you said. Thank you.
Thank you, Antal. Amnon, please.
Thank you very much for this wonderful presentation. I've certainly learned a lot, and I also enjoyed the dialogue or the interchange with Robert. I want to follow up on some of the things that were raised and maybe advance the conversation slightly forward. This notion of, I want us to think a little bit about this notion of de facto, right? So we say that from the perspective of international law, it is not clear, or maybe it is clear, but we don't want to state it, that there is a legality problem with these regimes to begin with, right? So therefore, we should have said these illegal regimes or non-legal regimes, depending on whether they're just against the law. I was in the midst of saying that this is this de facto, even the terminology of de facto as opposed to de jure, or in distinction from de jure, suggests that maybe it's an illegal regime to begin with. So maybe they contravene some international norm, or at least the international law doesn't know what to do with them, so they sort of lie somewhere in the, they float somewhere out there, and we don't really know how to deal with them, which I think warrants some discussion, because this notion of de facto, then the question, of course, is that to the extent that you legalize those de facto regimes by saying, okay, nonetheless, you have some duties, it's a form of legalization of those very regimes, and therefore you look at it with respect of state duties to comply or recognize or do something with it, but more conceptually, it's a question of legal units and analysis of what you mean by the de facto. Now, and de facto and legality. Now here, I want to again draw some relationship to what your recent exchange with Robert with respect to this notion of legitimacy, by suggesting that international law provides legitimacy towards the outside world, but also internally, and therefore maybe when the court is exercising its power against the executive, let's say, or legislature, it relies on international. But note this, that maybe from the perspective of those governed by the regime, international law is part of the problem. Why? Because international law deems them as illegal entity to begin with. So in those cases, actually relying explicitly on international law will undermine legitimacy. Don't tell us, don't use those legal sources because they actually see us as criminals. Why do you rely on them? So it's more complicated. The notion of what counts as justification is more complex than that. Now, I want to move towards the heart very quickly, to the heart of your argument with respect to theories of compliance. And there's one theory, again, and we see it, and I share Robert's methodology of drawing some analogies with other entities. There is another approach to compliance, and that is called the bricolage approach. Is more of in the school of legal realism, that suggests that courts have a sort of a professional instinct, let's call it, with respect to the preferred result they want to reach. Because they're professionals, they've been studying the law, legal principles. Now, then they have to provide reasoning. And then they turn to available sources. And this is what the term bricolage means. That is that which is available. So sometimes you turn to this, and sometimes you turn to this, and then there is some other trend. And you say, oh, I just read this article, why don't I use this? It doesn't do a lot of work in terms of the actual decision, but it does do work in terms of the reasoning. And then what's important, because international law in general, and international law in particular, is subject to a demand for consistency, right? Then the question is, when do they use which source? So for your methodology, and again, it follows up on something Robert said, it's not just when did they use it and when did they not. When did they use which source of international law? Are they consistent about it, right? So not just in cases where they had to pay a price. And here I disagree slightly with Robert. In other cases also, because if it's just bricolage, they would use it because it's easier on the shelf. They just turn their hand, we see this, let's take it. Doesn't matter, could it be milk or butter or mayonnaise, doesn't matter. Use any of these. But for it to be law, it has to be consistent. Okay, that's the point. The last point I want to raise, and then I've talked too much, but as you've mentioned, and also Robert mentioned this, international law is a large body of now, it would make, for me, it would be important to try to differentiate whether the instances where reliance, explicit or implicit, on the sections themselves or on the basic principles that correlate with, is done in cases that have more direct relationship to the armed conflict that underlies their illegality or non-legality or something like that, versus cases when it's just about running the territory because it's property, but sometimes property is related to the armed conflict because it could be other. So it's not just public law, private law, or criminal law, non-criminal law. It's whether the subject matter touches upon the political problem that undermines why they rebelled to begin with, the cleavage of conflict or the theater of conflict, let's put it this way, and whether it's about just running the population, ordinary routine of judicial review or some other issues of judicial independence, all those other issues that just go hand in hand with any, and then it might make a difference whether you turn to international law or not. Just a friendly suggestion to maybe look into that. Thank you.
May I answer? Yeah, thank you so much for all your very, very fascinating observations, Amnon. I start in the order you follow. So you started. So with the notion of de facto, absolutely. This enshrines this legality problem. They are so the existence of those groups is contrary to the state law, especially its criminal law, its public law, its constitutional regimes. But at least under some special regimes of international law, they are considered from a very pragmatic and neutral perspective. This is again the consequence of neutrality of international law towards those regimes, towards those armed opposition groups, especially from IHL and international human rights law, which observe the existence of those entities which are able to enforce those legal regimes in the territory they control. In other words, this is a kind of pragmatism, because and this also follows what Robert said, which is the claim that once they exclusively control a territory, they are the only one who can enforce IHL and international human rights law in the given territory. The question of legitimacy, certainly from the perspective of the domestic audience, so basically the population of the given armed opposition group, IHL is often an enemy, and there might be a hostility, and therefore what I am struggled with is what are the best techniques of the international community, and especially states and international organizations, to use the discursive force of international law to familiarize and also to make the population accept the use and the usefulness of international law. So I do not see here very much a problem of justification. The problem of justification comes from both sides. So international law as a discursive technique, how to really to persuade the audiences about the need and the usefulness of the compliance with international law. Here about the approach of bricolage. Yes, I have found these the techniques of bricolage with regards to compliance to understand state courts justification strategy. I certainly can subscribe that it is quite a useful explanation to understand the reasoning of both domestic courts and international courts. How here I do not see any difference from states. On the contrary, it is a fortiori applicable to armed opposition groups which are not formally bound, at least by those international law sources, but have even a wider margin of appreciation to cherry pick any source that is convenient to their respective outcome of the given case. Here, I just note that for many of the judgments I have found, it is also for pragmatic reasons, the courts and judges only apply those international sources which they know and which they have access to. Usually they do not go into a very complicated analysis of custom or analysis of sources other than treaty law. Rarely I have shown the importance of the case law from international courts, but when do they choose the same sources in a consistent manner is very much up to the given court. I found again some tendencies where from the the TRNC, the European Court of Human Rights case law is invoked, the same from Nagorno-Karabakh, whereas from the Donetsk People's Republic, it is rather basic treaty law that is analyzed and rarely the case law of the European Court of Human Rights. And your final observation about what about the judgments which have a more direct relationship with the armed conflict. This is and rather than about the administration of the territory. Again, this is a true conflict and true problem, which goes back to the empirical problem that those armed opposition groups rarely write down and rarely publish, even more rarely publish the military court judgments and especially their military case law, whereas the more stabilized and the more day-to-day administration questions the law relates, the more they are available for outside publication and for outside observers. This is also very much related to the problem how much the given armed opposition group respects the criteria of independence and impartiality of the tribunals. And here, I subscribe to the observation of many humanitarian experts that the most difficult of independence and impartiality is truly in military cases. Thank you.
Thank you, Antal and Amnon. The floor is to Shelley. We still have some more time for questions, so I encourage especially the students to ask. Let me know on the chat. Shelley, please.
Hi, Antal. Thank you for a very interesting talk. My question kind of draws on what Robert said. I was wondering whether you check compliance sort of by a factual assessment, whether a state complies or an armed opposition group complies with a requirement or not, and not by whether they use sort of the right words. You know what I mean? So that relates to Robert's sort of note, but also when you say that states do not have an interest to recognize the courts of armed opposition groups, I think like this is a different topic from whether they have an interest in the compliance of armed opposition groups with international law. it could be that states are very much interested that the armed opposition group will be complying with IHL, but they would not recognize their courts. I feel like those are two distinct topics. That's the main thing. And also I was thinking maybe different, you're talking about, and that kind of draws on Amnon, but you're talking about international labor law, international trade law, and IHL, international human rights law. And I think maybe there are different sort of reasonings to comply with each one of those bodies of law that makes it necessary to sort of understand them separately and not treat them as a full mechanism, because while they do sort of live together and they can apply at the same time, they sort of the reasoning behind them and the motivation to comply to them might differ vastly.
Yeah, but thank you so much for those questions. And well, I started all the discussion that my examples will be limited to fields other than international humanitarian law. For the said reasons, I do not have any examples of IHL court decisions by armed opposition groups, and that's why most of my and all of my examples are from other fields such as international labor law, international human rights law, or civil international cooperation in civil and criminal matters. The consequence in whether states have an interest in compliance by armed opposition groups, and what is the question, what is about the question of non-recognition or recognition. Yes, but the question is really the question is really chronological. So once we states recognize the interest of to comply, to ensure compliance by armed opposition groups, it also raises the question, what is the future? So what would it be recognizable and enforceable in the other states? Or is it, as it is today, is it really a provisional understanding of international law about the provisional existence of those armed opposition groups and tribunals for the sake of administering the given territory? And again, I see that this is very much the dominant state practice today. However, and perhaps a long-term perspective should also be promoted by states and international organizations, especially if a more viable status is searched by the international community. Thank you.
Oh, sorry, just maybe if I could rephrase what I said a bit, just to offer something. And of course, I haven't read the entire research, so maybe it doesn't sort of, maybe there are things there that I didn't get from that talk. But I think that from what I heard, the topic is actually international law in tribunals of armed opposition groups rather than the compliance of armed opposition groups. I think that's what you discussed here.
I think there is a relation, as far as there is a relation between the compliance of a state with international law and the compliance of the tribunals of a state with international law. So the tribunals are the organs of the given entity whose all the conduct is attributable to the given entity. This is rather uncontested. The more a court of an armed opposition group relies on international law and the more it follows in its decision, which are later supposedly enforced, the more one can say that the armed opposition group observes in its internal administration the rules of international law. I'm not sure whether it's clear enough, but I see a rather logical connection between compliance by a tribunal of a given entity and the compliance of the given entity with international law. And what I found is that the source of analyzing those decisions is a means to arrive to those conclusions. Thank you.
Thank you. And we have Ido. Ido, please.
Antal, thank you for a great presentation, and I really love the discussion that followed it. And one of the things that came up to my mind because of the discussion is a research that we used to have here at the Minerva Center and of Rivka Brot, who focused on the Jewish tribunals that were made up within the refugee camps following World War II. And that's a whole different aspect of non-state organizations or non-state entities that create their own judicial systems. And I don't have a question mark at the end of that, but I find it really interesting to look also from that perspective into your presentation.
I will certainly ask for the reference of this research. Thank
you. Maybe I'll add an observation, which I will be happy if you relate to. You know, most of these cases that you talk about, and these are really sub-cases of autonomous court system as Ido presented, but most of these cases, there is a mother country or protege country that supports the non-state territory. Okay, the Cyprus case, you know, is very obvious when Turkey is behind this non-state territory. And I would hypothesize that the attitude to international law and compliance with international law in those territories will be similar to the state that is actually supporting. And I think this is an interesting hypothesis to explore what is the compliance rate of international law in the territory and in the protege state.
Thank you. Yeah, and also the territorial state's own compliance, so which the armed opposition group is fighting against or opposing. So in much of the Caucasus region, there is a direct link between the compliance record of the territorial state and the given de facto regime. Whereas I just note that some of those de facto regimes, the examples such as the Kurdish autonomous region or the Gaza Authority, perhaps, do not necessarily have an outside state supporting those regimes. But it is certainly one of the interesting hypotheses I could build in. Thank you.
Thank you, Antal. And if there are no more questions, I want to thank you for this very stimulating talk, for all your comments and questions. And we'll meet again in 2 weeks' time. So thank you very much, Antal.
Thank you so much for the questions and for your patience. Thank you.